Supreme Court thing happened this last week, where Colorado decided to disqualify Trump from the ballot. Now, the way that happened is initially the Secretary of State was looking at, should I disqualify him because the insurrection article under the 14th Amendment. You can't take an oath and then commit an insurrection and then hold office ever again. So that went to I think it was the district court. The district court judge said, well, no, he did commit an insurrection. He did incite insurrection. He's guilty of that, right? Right, or he's liable for that, whatever. But the thing about it is she was like, I don't know that I can pull him off the ballot. So she kind of punted that. That then went to the Supreme Court of the state of Colorado, and they said, oh yeah, yank him from the ballot. This totally applies. So now that went to the Supreme Court, and we talked about it. Our theory was the Supreme Court's going to try to find a way to either punt this off onto Congress or somebody else, and they're not going to address it. Well, they heard that case this week, and we kind of got a sense of what they're going to do. So let's see if we were right. I'll give you a hint. We were right. Let's see if that
goes. U.S. Supreme Court justices on Thursday heard arguments on whether former President Donald Trump should be kicked off the ballot in Colorado over his actions on January 6, 2021, when his supporters attacked the U.S. Capitol. The justices took up the case after Colorado's top court sided with a group of voters who sought to remove Trump from the state's Republican primary ballot under the U.S. Constitution's 14th Amendment. Section 3 of that amendment bars from public office any, quote, officer of the United States who took an oath, quote, to support the Constitution of the United States and then, quote, engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof.
All right, so the Supreme Court heard arguments about it, and the interesting thing is they never addressed whether or not the insurrection thing was true. They avoided that. The only judge that really asked about it was Ketanji Brown Jackson. And she made it pretty clear that, yeah, he committed an insurrection in her questioning. But the other judges avoided it. What they asked was, can a state do that? And should we allow a state to do that? Because under the 14th Amendment of the Constitution, the concept is not to allow the individual states the right to pick and choose, right? Because they were trying to keep Confederate, members of the Confederacy from running from office again, right? Because they didn't want to go back into another civil war. At the time they wrote that back in 1866, right? So that was the whole point behind it. So it was to try and take because states typically handle their own elections, but it was by putting in the 14th Amendment, we say, well, yeah, you can do that, but these people you can't have in. But they ignored that point and just said, really, it shouldn't be up to the individual states to ban somebody. That should be a federal decision. So what they're basically looks like they're trying to do is say this: well, you have to keep him on the ballot because a state individually can't do it until somebody deems that he's, did the insurrection and that he's not. But that has to be a federal decision. But we're not going to address that at all. So we're just not going to make a decision. So basically, by not making a decision, we're saying we're making a decision and letting it slide. So the 14th Amendment has no teeth now. And you can kick it back to Congress, but that's a stupid argument because there's an amendment. Congress has already ruled. So that's essentially what's going on.
Yeah, so, God, I really didn't want to be right.
I know. I wish they'd had stood up and did the right thing, but watch this. This is CBS.
I mean, we kind of knew they wouldn't. They're pretty much spineless. They're kind of a joke at this point.
Yeah, they're a total joke. But here's CBS Primetime, and they're going to talk a little bit about this.
Supreme Court heard oral arguments over former President Donald Trump's eligibility to be on the 2024 ballot. The case hinges on the so-called insurrection clause of the 14th Amendment. The challenge comes from a group of Colorado voters citing Trump's involvement in the January 6th Capitol attack. Jessica Levinson joins us now for more analysis. She's a CBS News legal contributor and professor at Loyola Law School, who I was watching the minute the argument ended. So, Jessica, I'm glad to have you here so I can ask you all those questions I was asking when you couldn't hear me. I'm going to start off in the sort of complicated, which is, in addition to the 14th Amendment, there was a lot of discussion about something called the Griffin case. Can you tell us what that is and why that was discussed so much?
So this is a very old case that was decided by a former Chief Justice of the United States. And by very old, we mean more than 100 years old. But the reason it was discussed is because it dealt with disqualification and it dealt with a criminal prosecution, but it dealt with whether or not Congress has to provide guidance in certain areas. And that was what a lot of the argument was about here. Before a state like Colorado can throw somebody off the ballot, can say you're disqualified, do we first need to hear from Congress? Does there need to be a statute? We heard words like self-executing when they were talking about the Griffin case. What that really means is, can the state act like Colorado did and say, I'm looking at Section 3 of the 14th Amendment and Trump is not qualified? Or does a state have to wait for there to be a congressional statute, which is part of that Griffin case, and for Congress to say, states, you have the power, and states, here is some guidance?
And I'm going to come back to that in a second, but let me ask about another thing that was so much discussed, which is the idea that this wasn't a state power, as you said, that this might be something that Congress has to weigh in on. But states are given wide latitude to set the rules for federal elections. So how can states be given wide latitude to set the rules, but this is a rule that the state has to wait for Congress to tell it about?
Yes. So one of the classes I teach is election law, and there is this tension where, on the one hand, we do give states an enormous amount of power when it comes to designing election laws. We know that for people who've moved from state to state, you might have different voting ID laws. You might have different laws with respect to when you can vote, whether or not there's early voting, when you get your ballot, what the ballot looks like. But what the court said here is, we're talking also about the 14th Amendment. And the 14th Amendment, ratified in the wake of the Civil War, was in part about saying, states, we don't trust you. States, don't deprive people of equal protection. States, don't deprive people of life, liberty, or property without due process. And also folded into that is this idea of the 14th Amendment is about the federal government saying, states, we can't trust you. And that's, I think, why the court was able to say, yes, states get broad latitude. Yes, they get a lot of discretion in the election context, but there are certain places where we have to speak with one voice. There are certain places where we need national uniformity, and this is one of them.
Right, the spirit of the...
So the interesting thing about that is, and she's right about all that, but the interesting thing, and go on to Patreon, I cover this a lot more in detail. But the interesting thing about that is, if you're looking for guidance from Congress, what they're citing in Griffin, right? We already have guidance from Congress. Congress impeached him for insurrection. And that's what Colorado cited, and that's what the Supreme Court in Colorado cited. He was already impeached for this. He just wasn't convicted in the Senate. Right? So it's kind of one of those, it's like it's the Supreme Court saying, well, there needs to be guidance from Congress, but that's not really up to us, so we don't have to decide it. So once again, it's them basically saying, we're not going to decide if there was an insurrection. We're not going to decide whether or not he's eligible. We're not going to decide what Congress found. We're not going to decide what was previously discussed or found. We're just going to say, look, this really shouldn't be left up to the states individually, which is a decent argument. But then the question is, well, then who handles it? And the Supreme Court's basically saying, not us.
Hot potato.
Hot potato. You take it. You take it.
Hot potato. Oh, wait, but you don't get to take it. Here, you guys take it.
Yeah. So that's it. I mean, that's, in a nutshell, that's what it is. I mean, I go into more detail. Hillary Clinton actually had a pretty good take on this, too. And there was a couple, Lawrence Tribe had some good takes, and so did, what's his name? I forget his name. Littman or something like that. It was another judge, had a really good take on this. But yeah, check us out on Patreon if you want to get more detail on that. But that's basically, it looks like they're just going to try and pass the buck. And they're just going to say, yeah, you have to leave them on the ballot until we hear something from Congress or somebody, whoever that may be, we don't know. So basically, it's a law with no police to enforce it. You know,
at every turn, this just becomes even bigger of a mess.
Yeah, but it's basically nobody wants to step up and, you know, grow a pair. You know.
Yeah, everyone wants these highfalutin positions and honor and all of that sort of stuff, but when it comes down to actually doing the job that is associated with it, they don't want to.
Yeah, everybody wants to say they're a Supreme Court justice, but nobody wants to do it. Yep. Nature of the world.